Dimitrios Giannoulopoulos. I'm a professor of law and head of the Department of Law at Goldsmiths University of London. Tonight, we have the unique pleasure of inaugurating an annual human rights lecture series, asking the crucial question about how human rights and climate change intersect. And we're deeply honored that the lecture will be delivered by Judge Tim Eicke, judge at the European Court of Human Rights in respect of the United Kingdom. A dual British-German national, Judge Eicke studied law at the universities of Passau and Dundee. Before taking up his current appointment, he was a barrister at Essex Court Chambers and was appointed a Queen's Counsel in 2011. Since 2014, he has been a bencher of Lincoln's Inn. While in practice, Judge Eicke regularly argued cases in the UK Supreme Court, the Court of Justice of the European Union, and the European Court of Human Rights, and acted both for claimants and governments. He was a member of the Equality and Human Rights Commission panel of counsel and edited the European Human Rights Reports. Judge Eicke is a member of the American Society of International Law, and since 2011, he has been a member of the Public International Law Advisory Panel of the British Institute of International and Comparative Law. He was a trustee member of Board of Directors of the IRA Center between 2000 and 2008, and of Interrights between 2004 and 2015. In 2017, he received an honorary doctorate from the University of Dundee. Since October 2020, he is Vice President of Section 4 of the Court. His expertise covers human rights law, the law of the European Union, public international law, as well as UK public and constitutional law. Judge Eicke will be addressing the issue of human rights and climate change, what role for the European Convention on Human Rights. As the European Court of Human Rights' first climate case is currently pending before the court, Duate, Agostinho and others, and Portugal and others, in this inaugural annual human rights lecture, Judge Eicke will reflect on the opportunities and challenges of using the ECHR as a forum for climate change litigation. Whilst indirect protection of the environment through rights such as the right to life, the right to private life, or the right to fair trial has long been recognized by the court, significant limitations may still stand in the way of a successful climate-related claim. Judge Eicke will explore in particular how the Convention's strict standing requirements, the highly political dimension of decision-making in the field of climate policy, and jurisdictional issues all represent challenges that have the potential to constrain the role the Convention can play in addressing climate change. But Judge Eicke will also remind us that the Convention is a living instrument that has many times proved itself capable of adapting to current human rights challenges. Our warden, or Vice Chancellor, Frances Corner OBE, is sending her apologies for not being able to attend tonight as a result of prior commitment. And along with that, she's sending a warm welcome to Judge Eicke and a message about the importance of the subject he is addressing tonight for our academic and student community. Human rights and climate change are two issues of critical importance to the Goldsmiths community and for our very future as an institution, she notes. Here at Goldsmiths, we know that urgent action is needed to tackle climate change, its impact on our planet and on people across the world. We believe that these two global challenges are intrinsically linked. This is why Goldsmiths declared the climate emergency in 2019 and launched a Green New Deal, committing to carbon neutrality by 2025 and enhancing the campus for wildlife and human health. Goldsmiths is committed to using teaching and research to tackle climate injustice through education, equipping future generations to take on this challenge and campaign for change. It is the same passion that we share as a Department of Law for International Human Rights. Our academic staff and visiting professors are leading experts in human rights. We work closely on human rights issues with barristers' chambers, NGOs, and the Inns of Court. In the last 3 years alone, in the context of our Knowing Our Rights research project, we have visited more than 50 secondary schools and connected with over 2,500 students to discuss the positive influence of the European Convention on Human Rights in the UK. And we are very privileged to collaborate with the Council of Europe and European Court of Human Rights. I cannot emphasize enough the importance of having you here with us tonight, Judge Eicke, to deliver our inaugural annual human rights lecture on such a crucial issue that means so much to us as a community of scholars and students. Judge Eicke will now deliver the annual lecture. My colleague, Dr. Virginie Barral, our environmental law expert, will then offer a reflection on Judge Eicke's lecture before Judge Eicke takes the opportunity to answer questions from the audience. Thank you. Judge Eicke, the floor is yours.
Thank you very much, Professor Giannoulopoulos, for those kind words of introduction and for inviting me to give the inaugural annual human rights lecture. Thank you all. Please also pass on my thanks to the warden for her kind words of welcome. It's a great honor to have been invited by you to give this inaugural annual human rights lecture, which you organize in the Department of Law at Goldsmiths University. I'm just sorry that the circumstances are such that I cannot be with you in person. As much as Zoom seems to almost have become the new normal, it cannot replace the personal exchange with the students and other participants, both generally and bilaterally, over the after-event coffee or drink, which events like these facilitate, and which for me are almost invariably the most enriching aspects of an evening like today. Let's hope that we will soon be in a position to get together again to debate the pressing issues of the day. And of course, no issue is more pressing than the topic of tonight's lecture, climate change. In fact, it has recently been described as the biggest threat to security that modern humans have ever faced. Let me start my lecture with a slightly longer quote from the same source. I quote, "Today there are threats to security of a new and unprecedented kind. They are rising global temperatures and the despoiling of the ocean, that vast universal larder on which people everywhere depend for their food. Changes in the pattern of weather worldwide that pay no regard to national boundaries, but that can turn forests into deserts, drown great cities, and lead to the extermination of huge numbers of the other creatures with which we share this planet. No matter what we do now, some of these threats will assuredly become reality within a few short years. Others could, in the lifetime of today's young people, destroy entire cities and societies, even altering the stability of the entire world. The heating of our planet has already reached the point that the impacts on the poorest and most vulnerable people are profound. But this is only the beginning of the crisis. We are today perilously close to tipping points that, once passed, will send global temperatures spiraling catastrophically higher. If we continue on our current path, we will face the collapse of everything that gives us our security: food production, access to fresh water, habitable ambient temperature, and ocean food chains. And if the natural world can no longer support the most basic of our needs, then much of the rest of civilization will quickly break down. We have left the stable and secure climatic period that gave birth to our civilization. There's no going back. No matter what we do now, it's too late to avoid climate change. And the poorest and most vulnerable, those with the least security, are now certain to suffer. Our duty right now is surely to do all we can to help those in the most immediate danger. But of course, we have a parallel duty, and it's here where I think there are grounds for hope. While it's true that we can never go back to the stable, benign climate that enabled us to flourish for the past 10,000 years, I do believe that if we act fast enough, we can reach a new stable state." End quote. These are the words addressed by Sir David Attenborough to the UN Security Council little more than a week ago. There can, of course, now no longer be any doubt about the scale of the problem and the science behind it. The real is, what concrete steps are we, individually and collectively, willing and able to take in order to reach that new stable state? Sir David, in his address, highlighted an important aspect of the challenge this poses when he said to the UN Security Council, and I quote again, "Climate change is a threat to global security that can only be dealt with by unparalleled levels of global cooperation. It will compel us to question our economic models and where we place value, invent entirely new industries, recognize the moral responsibility that nations have to the rest of the world, and put a value on nature that goes far beyond money, end quote. In a world that continues to be structured on the basis of sovereign equality between nation states, and in an era in which past and future moves towards a post-Westphalian model are actively being called into question, it is only appropriate that the first port of call for identifying and making the systemic changes necessary to meet this challenge, as well as the necessary global cooperation, are the respective legislatures as well as executives. This is one of the hallmarks of living in a democratic society governed by the rule of law. The deliberative process that involves has, of course, also already led to a number of positive developments, both nationally and internationally. To name but a few, one might point to the UK Climate Change Act 2008 and the Independent Climate Change Committee set up thereunder, the relevant EU climate change legislation binding on the now 27 member states, the Aarhus Convention, or the 2015 Paris Agreement. On the other hand, this process has also exposed the scale of the challenges, both political as well as social, identified by Sir David in adopting the necessary standards as well as in their implementation. Again, just two examples. The first is the debate currently going on in France, where in 2019, President Macron created a citizens' convention on climate, consisting of about 150 citizens selected at random, with the promise that he would be submitting their legislative and regulatory proposals without a filter, either to a referendum, to a vote in Parliament, or to direct implementation. However, the recently presented climate bill has been subject to considerable criticism for only reflecting a small proportion of the Convention's more than 150 interrelated proposals. The other, more obvious international example is, of course, the withdrawal, now reversed, of the United States from the Paris Agreement and the accompanying domestic policies adopted under the previous administration, not to speak of some of the policies of other major polluting nations. But leaving these difficulties aside, the deliberative processes involved always take a considerable amount of time which Sir David reminds us we do not have, and ultimately, frequently, only lead to legislative texts which either commit states, and therefore largely the executive, to adopt or operate by reference to certain standards, or which impose certain standards on private actors, all of which require further practical implementation and supervision. It is perhaps not surprising, therefore, that some concerned citizens, and we should of course all be concerned citizens, turn to the courts with the hope of obtaining a more concrete legal remedy towards ameliorating the consequences of past failings and towards helping us achieve the new stable state. While parties bringing such proceedings, as in the recent judgment of the UK Supreme Court in Friends of the Earth against Heathrow, most frequently seem to rely primarily on already existing legally binding requirements or obligations, and merely seek to supplement or strengthen their arguments by also relying on the European Convention on Human Rights, there are now an increasing number of proceedings seeking to rely only or mainly on the ECHR. The most prominent successful example of this latter kind of litigation before a national court is, of course, the December 2019 Urenda judgment of the Dutch Supreme Court, which I will mention again briefly later. There are two other cases in this later category, which I should specifically identify now, one of which Professor Giannoulopoulos referred to in the introduction, that are currently pending before the European Court of Human Rights. The reason I should identify them now is that I will be able to say relatively little about them, because it seems to me that it would be inappropriate for me as a sitting judge to comment on the substance or the merits of a pending case. The first of these cases is, of course, Duate Agostinho against Portugal and 32 other states. This case was brought directly to the European Court of Human Rights and was communicated to the respondent states on the 13th of November 2020. And it was given priority by the president of Section 4, my own section at the court. The applicants complain that the respondent states have failed to comply with their positive obligations under Articles 2 and 8, as well as Article 14 of the Convention, read in the light of the commitments made within the context of the 2015 Paris Agreement to limit the increase of the average temperatures of the planet significantly below 2 degrees centigrade in comparison with the pre-industrial levels, and to seek to limit the temperature rise to 1.5 degrees centigrade by comparison with pre-industrial levels. The second such case is the application brought by the Verein Klimaseniorinnen Schweiz against Switzerland, following their unsuccessful proceedings before the domestic court. This application was apparently submitted at the end of November 2020 and has not yet been communicated to the respondent state. In fact, in preparing for this lecture this afternoon, I came across to a press release of today of a third case lodged with the court, and it appears directly to be lodged with the court, and that is by an individual called Mex M against Austria, an applicant who suffers from the Uthoff syndrome, a form of multiple sclerosis which worsens with increasing temperatures, whose lawyers have promised or have indicated that they will lodge proceedings with the court at the end of March this year. Now, having taken rather longer to introduce the topic and the context, let us turn to the role of the European Convention and, more importantly, the Court of Human Rights in the struggle to ensure that we achieve the new stable state Sir David referred to. The starting point for this part of our analysis, in my view, is inevitably to note two things. First, that the 2015 Paris Agreement itself, apparently deliberately as a result of objections, amongst others by a number of state parties to the ECHR, contains no substantive provision making the link between climate change and human rights. In fact, the only mention of human rights in the Paris Agreement is in its preamble, acknowledging that parties should, when taking action to address climate change, respect, promote, and consider their respective obligations on human rights. The second point to bear in mind is that the ECHR itself is, of course, a human rights treaty concluded as long ago as 1950, and as a consequence, as the court has repeatedly confirmed, is, I quote, not specifically designed to provide general protection of the environment as such. To that effect, other international instruments and domestic legislation are more pertinent, end quote. Despite the fact that since about 1999, the Parliamentary Assembly of the Council of Europe has repeatedly recommended that this lacuna should be remedied either by an amendment or an additional protocol to the ECHR, providing for the right of individuals to a healthy and viable environment, this recommendation has been rejected by the Committee of Ministers on the basis that the convention system already indirectly contributes to the protection of the environment through existing convention rights, and their interpretation in the evolving case law of the European Court of Human Rights. So that's where we are in terms of the legislative framework, but it will not surprise you to hear that this has not discouraged applicants from seeking over the years to invoke the convention in the name of environmental protection. While there have not so far been, to my knowledge, any specific climate change decisions, a search of HUDOC, the court's case law database, shows that the Strasbourg organs have to date handed down more than 300 decisions and judgments in cases raising environment-related issues. So let's have a look at that case law, both in respect of the substantive provisions under the Convention and the procedural requirements, both in terms of domestic proceedings as well as in relation to the jurisdiction and the admissibility of cases before the ECHR itself. As long ago as 1978, in its famous Tyra judgment, the court recalled that the Convention is a living instrument which must be interpreted in light of present-day conditions. The court cannot, so the court said, but be influenced by the development and commonly accepted standards in the member states of the Council of Europe. This living instrument doctrine is a fundamental component of the court's approach to the interpretation of the Convention as, first and foremost, a system for the protection of human rights. Consequently, the court will have regard to the changing conditions within the respondent state and within contracting states generally, and respond, for example, to any evolving convergence as to the standards to be achieved. Although the court expressly acknowledged as early as 1991 that in today's society the protection of the environment is an increasingly important consideration, it has not always been easy to identify the existence and or the content of these commonly accepted standards or any evolving convergence, insofar as they are different standards or different questions, at least at a macro level. By way of example, one only needs to compare the reluctance of states to commit to a clear linkage between human rights and climate change in the relatively recent Paris Accord to the view expressed by the dissenting judges in the case of Hatton against the United Kingdom. In that case, the Grand Chamber held by a majority that in adopting its 1993 policy on night flights at Heathrow, the UK government had not overstepped the wide margin of appreciation by failing to strike a fair balance between the right of the individual affected and of the community as a whole. The court found that there had therefore been no violation of Article 8. However, in their dissenting opinion, Judges Costa, Ress, Turman, Supancic and Steiner disagreed. Relying on the living instrument doctrine and referring to the 1972 UN Declaration on the Human Environment and the EU Charter of Fundamental Rights, they considered that, and I quote, "These recommendations show clearly that the member states of the European Union want a high level of protection and better protection, and expect policies aimed at those objectives. On a broader plane, the Kyoto Protocol makes it patent that the question of environmental pollution is a supranational one, as it knows no respect for boundaries of national sovereignty. This makes it an issue par excellence for international law and a fortiori for international jurisdiction. In the meanwhile, many Supreme and Constitutional Courts have invoked constitutional vindication of various aspects of environmental protection on these precise grounds. We believe," they said, "that this concern for environmental protection shares common ground with a general concern for human rights," end quote. That, however, has remained, at least to date, a minority opinion. And in order to engage Article 8, the court has so far insisted that the adverse effects of environmental pollution must attain a certain minimum level, an assessment which by definition is relative and depending on all the circumstances of the case, such as the intensity and duration of the nuisance and its physical or mental effects. The general context of the environment should also be taken into account. There would be no arguable claim under Article 8 if the detriment complained of was negligible in comparison to the environmental hazards inherent to life in every modern city, end quote. As Judge Pavli, my Albanian colleague, noted in his partly dissenting opinion in the recent case of Hudorovic and others against Slovenia, I quote, "What matters is whether the environmental hazard has caused significant impairment to one's ability to enjoy one's home, considering aspects such as the intensity and duration of the nuisance and its physical and mental effects on health and quality of life," end quote. Nevertheless, the threshold is not such as to exclude claims not seriously endangering their health. Perhaps most relevant to any potential climate change litigation, one can see that in these cases, the court has not limited itself to analysing the complaint of an interference by a public authority, i.e. a negative obligation, but has frequently analysed such complaints by reference to a positive obligation on the state to take reasonable and appropriate measures to secure the applicant's rights under Article 8. Such a positive obligation may include, amongst others, a right to adopt, maintain, and operate an appropriate regulatory regime. In any event, no matter how a complaint is ultimately analysed, the court has confirmed that, and I quote, "The applicable principles regarding the balance between the rights of an individual and the interests of the community as a whole are broadly similar," end quote. That said, where the state is required to take positive measures, the choice of means is, according to the court, in principle a matter that falls within the contracting state's margin of appreciation. So under the court's existing case law, certainly in cases concerning broader policy choices, the margin of appreciation left to states in the sphere of environmental protection has generally been held to be wide, leaving the court to consider only whether there has been a manifest error of appreciation by the national authorities in striking a fair balance between the competing interests of different private actors. Due to the complexity of the issues involved, the court has generally seen its role as primarily subsidiary, limited to examining first whether the decision-making process was fair and afforded due respect to the interests safeguarded to the individual by Article 8. Only in exceptional circumstances will the court go beyond this line and revise the material conclusions of the domestic authorities. That said, in its recent judgment in Cordella and others against Italy, the court did not describe the margin of appreciation as being wide. Instead, it referred to the state enjoying a certain margin of appreciation. Whether this signifies a greater willingness on the part to engage with national policy remains to be seen. Consequently, where the court has found a violation of Article 8, this has frequently been in respect of a failure by authorities to complete an aspect or other of the domestic legal or regulatory regime, such as a failure of the licensing regime or a failure to comply with freedom of information legislation. Nevertheless, the court has also made clear that mere compliance with domestic law does not per se resolve the issue in favor of the state. Domestic legality is only one of many aspects which the court said should be taken into account in assessing whether the state has struck a fair balance in accordance with Article 8.2. When confronted with environmental disasters that have caused or threatened to cause loss of life, the court has also found, frequently in addition to Article 8 and sometimes Article 1 of the First Protocol, the protection of property, that Article 2, the right to life, was engaged and had been breached. The Grand Chamber helpfully summarized its case law on the obligations arising under Article 2, beyond the negative obligation to refrain from the intentional taking of life, in its recent judgment in Nicolae Tănase against Romania in the very different context of a serious road traffic accident. These obligations include, most relevantly in the present context, a primary substantive procedural obligation to put in place an appropriate legislative and administrative framework, including the making of regulations to compel institutions, whether private or public, to adopt appropriate measures for the protection of people's lives. In these cases, Article 2 may well apply, despite the fact that there is no direct state responsibility for placing the applicant's life in danger. Article 2 also imposes a further substantive positive obligation to take preventive operational measures to protect an identified individual from another or even from themselves, the so-called Osman duty. However, the court has significantly circumscribed this obligation by, on the one hand, stressing that this obligation must be interpreted in a way that does not impose an impossible or disproportionate burden on the authorities, and by, on the other hand, making its application subject to the requirement that it has to be established by an applicant that the authorities knew or ought to have known at the time of a real and immediate risk to the life of an identified individual or individuals. Once triggered, however, this duty requires the state to take measures within the scope of its powers that, judged reasonably, might be expected to avoid the identified risk. While the court has not yet had to decide this issue itself, one can see a potential extension of this approach in the recent decisions of the UN Human Rights Committee and by the Tribunal Administratif de Toulouse, as well as by the Cour Administrative d'Appel de Bordeaux, concerning those sometimes referred to as climate refugees. But in light of what I've said so far, it seems to be that the Secretary General of the Council of Europe, the President of the Committee of Ministers, the President of the Parliamentary Assembly, and the then President of the Court of Human Rights were probably right when, in their joint statements of the 29th of January 2020, at the launch of the 70th anniversary of the ECHR, and referring to the living instrument doctrine, they said that the Convention has repeatedly proved itself capable of adapting to new human rights challenges. This adaptability will be crucial in helping the continent to face emerging challenges to individuals' rights linked to threats to the natural environment. Let's now turn from the substantive to the procedural aspects of the court's case law in this area. In its judgment in Tashkin and others against Turkey in the context of environmental law, the court has explained that the state's procedural obligations consist of three separate obligations. Where a state must determine complex issues of environmental and economic policy, the decision-making process must, so the court said, firstly involve appropriate investigations and studies in order to allow them to predict and evaluate in advance the effects of those activities which might damage the environment and infringe individuals' rights, and to enable them to strike a fair balance between the various conflicting interests. The court went on to say that the importance of to the conclusions of such studies and to information which would enable members of the public to assess the danger to which they are exposed is beyond question. Lastly, the individuals concerned must also be able, so the court said, to appeal to the courts against any decision, act or omission where they consider that their interests or their comments have not been given sufficient weight in the decision-making process. The specific article of the convention that is invoked in this context is of lesser relevance, as the court noted in the context of dangerous activities that the scope of the positive obligations under Article 2 and Article 8 largely overlap. The positive obligation under Article 8 requires national authorities to take the same practical measures as those expected of them in the context of their positive obligations under Article 2. In what may be seen as an otherwise surprising dearth of reference to and reliance on related international treaties in the court's case law on environmental law, it is in identifying and developing these so-called participatory rights the court has most clearly drawn support and inspiration from other international instruments in the field of environmental law, and especially from the 1998 Aarhus Convention. This reflects the fact that the court has elsewhere accepted the existence of a joint European and international stance on the need to protect access to the cultural heritage on the basis that, and I quote, the provisions of the Convention cannot be interpreted and applied in a vacuum. Despite its specific character as a human rights instrument, the Convention is an international treaty to be interpreted in accordance with the relevant norms and principles of public international law, and in particular in light of the Vienna Convention on the Law of Treaties. Thus, the court has never considered the provisions of the Convention to be the sole framework of reference for the interpretation of the rights and freedoms enshrined therein. On the contrary, account should be taken, as indicated in Article 31(3)(c) of the Vienna Convention, of any relevant rules of international law applicable in the relations between the parties, and in particular the rules concerning the international protection of human rights, close quotes. That said, it is, however, also in this procedural context that some of the main difficulties in relation to climate change litigation may well arise. Looking at the domestic context first, the court has made it clear that individuals concerned must also be able to appeal to the courts against any decision, act or omission where they consider that their interests or comments have not been given sufficient weight in the decision-making process. This is what the court said in the Tashkin judgment. However, when it comes to asserting or defending that right, by reference to Article 6 of the Convention, the right to access to court and to a fair hearing, the dominant line of the court's case law makes it clear that in fact challenges by individuals to decisions of major environmental impact do not necessarily engage in individuals' civil rights and obligations so as to render Article 6 applicable. Article 6 will apply only where an applicant can show that it exposes them personally to a danger that was not only serious, but also specific and above all imminent. One or two decisions in the meantime appear to have been more accommodating, but although they do not appear to have had any lasting impact on the underlying approach of the court, they have left the court's case law in a certain degree of uncertainty. As a result, on occasion, the court has sought to draw a distinction between, on the one hand, that aspect of the dispute relating to defense of the public interest, which it held did not concern a civil right and therefore did not engage Article 6, and on the other hand, the repercussions of a decision on the lifestyle and properties of the applicants, which in turn did engage Article 6. The only exception to this approach, if in fact it is an exception, can be found in a line of cases against Turkey, in which the applicants had already successfully challenged the original measures before the highest domestic courts on the basis of the risks they posed to their interests. Their complaint before the Strasbourg courts, therefore, was in effect that, in breach of Article 6 of the Convention, those final judgments in their favour, their final domestic judgments, had not been implemented or had been ignored by the national authorities. This same restrictive approach to access to court is in fact also reflected in the court's case law in relation to both the applicability ratione materia of the substantive rights, as well as to the admissibility of an application to the court under Article 34 of the Convention more generally. In relation to the former, that is the applicability ratione materia of Articles 2 and 8 of the Convention, as well as Article 1 of the First Protocol, the Court has made it clear that although Article 8 has been relied on in various cases involving environmental concern, it is not violated every time that environmental deterioration occurs. No right to nature preservation is as such included among the rights and freedoms guaranteed by the Convention. Thus, in order to raise an issue under Article 8, the interference must directly affect the applicant's home, family, or private life. In relation to the latter, that is, admissibility of an application under Article 34 of the Convention, it is perhaps important to note that the article itself provides that the court may receive an application only from an applicant claiming to be the victim of a violation of the rights set forth in the Convention. To date, the court has interpreted this requirement always as being, and I quote, autonomous and irrespective of domestic concepts such as those concerning incapacity to act. In addition, in order for an applicant to be able to claim to be a victim of a violation of the Convention, there must be a sufficiently direct link between the applicant and the harm which they consider they have sustained on account of the alleged violation, end quote. This focus on a serious, specific, and imminent risk to an applicant, of course, poses a very real obstacle to litigation brought by public interest organizations and non-governmental organizations, unless they can show, for example, that they were set up for the specific purpose of defending their members' interests before the courts, and that those members were directly concerned by the decision at issue. Or they can show that a domestic judgment in their favor had not been executed. Now, this approach of the court is, however, not an inadvertent development of the court's case law or an unintended limitation on access to the court. Looking at the old case law, it seems that quite the contrary is the case. The court's consistent case law under Article 34, as well as under Article 6, has so far consistently held that, I quote, the Convention does not allow complaints in abstracto alleging a violation of the Convention. The Convention does not provide for the institution of an actio popularis, meaning that applicants may not complain against the provision of domestic law, a domestic practice, or public acts simply because they appear to contravene the Convention. In order for applicants to be able to claim to be a victim, they must produce reasonable and convincing evidence of the likelihood that a violation affecting them personally will occur. Mere suspicion or conjecture is insufficient in this respect, end quote. This case law, therefore, appears to leave, at least as it stands at the moment, little scope for the application of the precautionary principle. It is perhaps worth noting, in passing at least, that a request for an advisory opinion under Protocol 16 to the Convention is not, unlike Article 34, as a matter of convention law subject to the admissibility requirements in Article 34. Protocol 16 enables the nominated highest courts of a party to that protocol to ask the court for an advisory opinion on questions of principle relating to the interpretation or application of the rights and freedoms defined in the Convention. However, currently the UK has neither signed nor acceded to this protocol. Now, I mentioned earlier that the court tends to look for and be guided by, to some extent, developing common approaches across Europe and looking at the actia popularis versus individual victim dilemma I've identified that has confronted the court throughout its history. It is clear that that has also troubled and continues to trouble the domestic courts without a clear consensus becoming apparent. By way of example, in the Ogenda judgment I mentioned earlier, the Dutch Supreme Court overcame this difficulty by concluding that the NGO in question, which represents the interests of the residents of the Netherlands with respect to whom the positive obligation under Articles 2 and 8 applies, can invoke this obligation. After all, the court said, the interests of those residents are sufficiently similar and therefore lend themselves to being pooled, so as to promote efficient and effective legal protection for their benefit, end quote. But one only has to contrast that with the judgment in the Friends of the Irish Environment judgment of the Irish Supreme Court, where that court has again endorsed an approach under the Irish Constitution that seems akin to that adopted by the court, namely that a plaintiff needs to be able to demonstrate that they have been affected in reality or as a matter of fact by virtue of the measure which they seek to challenge on the basis that it breaches rights. In its decisions of the 5th of May 2020 in the case of Verein Klimasenioren in Schweiz, the Swiss Federal Court adopted a similar approach. But it may also be of interest to note that the Irish Chief Justice in the case I just mentioned went on to accept that there might be circumstances in which it is permissible to accord standing outside the bounds of that basic principle. But he indicated that these must, and I quote, necessarily be limited and involve situations where there would be a real risk that important rights would not be vindicated unless a more relaxed attitude to standing were adopted, end quote. Furthermore, I should perhaps also draw attention to a connected point that arises from the court's jurisprudence, which, in this context, which is the risk perceived or real to the separation of powers, or at the international level, to the principle of subsidiarity, and the risk of the judicialization of public administration. In the case of Atanasoglu against Switzerland, the court expressly noted and rejected the suggestion that it was possible to, and I quote, derive from Article 6.1 of the Convention a remedy to contest the very principle of the use of nuclear energy, or at least a means for transferring from the government to the courts the responsibility for taking, on the basis of the technical evidence, the ultimate decision on the operation of individual nuclear power stations, end quote. On the contrary, the court in that judgment underlined that the decision how best to regulate the use of nuclear power is a policy decision for each contracting state to take according to its democratic processes. Article 6.1 cannot be read as dictating any one scheme rather than another, the court concluded. This concern can also, of course, be seen in more modern and more recent national cases, such as, for example, the reasoning of the majority in the US Court of Appeals for the Ninth Circuit in the Juliana decision, where the court directed the dismissal of a group action in relation to climate change-related injuries on the basis that, and I quote, as the opinions of their experts make plain, an effective plan would necessarily require a host of complex policy decisions entrusted, for better or worse, to the wisdom and discretion of the executive and legislative branches. These decisions range, for example, from determining how much to invest in public transport to how quickly to transit to renewable energy, and plainly require consideration of competing social, political, and economic forces, which must be made by the people's elected representatives, rather than by federal judges interpreting the basic charter of government for the entire country, end quote. Finally, connected to this is yet a further potential issue, which was recently highlighted by the question posed to the Court of Justice of the European Union in the Deutsche Umwelthilfe against Freistaat Bayern case, naming the risk of the executive of the state failing or refusing to implement the judgments handed down. Something that would pose a real risk not only to the institutional balance and to the standing of the court within the European human rights system, but also ultimately to the rule of law. In the Deutsche Umwelthilfe case, the Court of Justice was asked in apparent desperation, and I quote, whether EU law must be interpreted as meaning that, in circumstances in which a national authority persistently refuses to comply with judicial decisions enjoining it to perform a clear, precise, and unconditional obligation to take the necessary measures to comply with the prescribed nitrogen dioxide emission levels, empowers or even obliges the national court having jurisdiction to order the coercive detention of office holders involved in the exercise of official authority, end quote. Before concluding, let me raise one final issue that will also almost inevitably arise in climate change-related litigation as a result of the interplay between, on the one hand, the fact that climate change is a global problem that needs to be solved globally, and that emissions of greenhouse gases take place from the territories of all countries, that all countries are affected and that measures will have to be taken by all countries on the one hand, and on the other, the perhaps old-fashioned Westphalian framework of reference underlying the Convention. That is the focus set out in Articles 1, 19, and 34 of the Convention on the individual state as a respondent and on that state's obligation to secure to everyone within its jurisdiction the rights under the Convention. This issue is, of course, brought into sharp relief by the application in Duate Agostinho versus Portugal and 32 other states. And as I've said, as this case is currently pending, I will say no more about it other than to identify the issue and to draw attention to one potentially relevant case. And that case concerns the application in relation to the destruction of a site of historic and scientific interest brought against Turkey, Austria, and Germany, in which the court indicated that as all measures were taken in and all relevant legal proceedings had been taken before the courts of Turkey, the fact that Austrian and German companies were directly involved in the actual destruction was not per se sufficient to bring a case against either of those two latter states. The application against them was rejected as inadmissible ratione personae by reference to the court's established case law that a state's jurisdiction was primarily territorial and that extraterritorial jurisdiction would only exceptionally be found, namely in cases of state agent control or effective control over an area outside their territory. It has repeatedly been suggested that the court might be able to resolve this issue by reference to the concept of state responsibility and the recognition in Article 47 of the ILC's Articles on Responsibility of States for Internationally Wrongful Acts, that where several states are responsible for the same internationally wrongful act, the responsibility of each state may be invoked in relation to that act. Again, no doubt arguments to this effect may well be developed before us in an appropriate case. But it is perhaps worth noting that the court has so far at least taken the position that the test for establishing the existence of jurisdiction under Article 1 of the Convention cannot be equated with the test for establishing a state's responsibility for an internationally wrongful act under general international law, because the latter is logically dependent upon the former having been established. That said, in a more recent development in the context of cross-border crime, in emphasizing the Convention's special character as a treaty for the collective enforcement of human rights and fundamental freedoms, the court has indicated that this special character may in some circumstances imply a duty for contracting states to act jointly and to cooperate in order to protect the rights and freedoms they have undertaken to secure within their jurisdiction. It will remain to be seen how far this duty to cooperate will be confined to the context of cross-border crime and the investigation of crime and the subsequent and consequent procedural obligations to investigate under Article 2 of the Convention. Now, having taken you on this tour of the court's existing case law, and I hope identified some of the opportunities challenges in using the European Court and the Convention of Human Rights as a forum for climate change litigation. Let me finish by quoting the current president of the court, Judge Spano, and quote what he said at a conference held as part of the celebrations of the 70th anniversary to the convention. He said, and I will close with this, that the already established case law in environmental cases before the court demonstrates a certain conceptual trajectory, the logical extension of which remains to be determined by the court using its traditional methodological approaches. We are present in a transformative moment in human history, a moment of planetary impact and importance. No one can legitimately call into question that we are facing a dire emergency that requires concerted action by all of humanity. For its part, the European Court of Human Rights will play its role within the boundaries of its competence as a court of law, forever mindful that convention guarantees must be effective and real, not illusory. End quote. Thank you very much.
Thank you very much, Judge Eicke, for such an enlightening and thought-provoking lecture, for highlighting the extraordinary circumstances in relation to the impact of climate change upon human rights that we are facing as individuals, as individual nations, and as a community of nations, which are or should be bound by international law. Thank you also for clearly demonstrating to us the willingness, if I understood you correctly, of the court to play an important role in the protection of the environment and to ensure that convention rights are indeed effective and real, not illusory, as you have concluded, quoting the president of the court, Judge Spano. Thank you, finally, for highlighting the important, I think, procedural, institutional, cultural, socio-political obstacles that the court might face in its effort to protect human rights in the context of climate change, and for indicating, at the same time, potential creative solutions about how to overcome them. At this stage, I would like to introduce my colleague, Dr. Virginie Barral, who is an expert in international environmental law, with leading expertise in the right to water and on sustainable development and environmental law more broadly, and who has previously worked for the French Commission for Sustainable Development. Virginie is going to offer a quick reflection on Judge Eicke's lecture. Virginie?
Thank you very much, Dimitrios. Well, thank you very much, Judge Eicke, for this fascinating picture of where the court finds itself and the role it could play in the face of the challenge posed by climate change, and really in a context where climate litigation, which was still a rather niche area of judicial activity not so long ago, is today not only rising exponentially, but really being used as a prominent tool of climate action. So you tell us in your conclusion that you have taken us on a tour of the court's case law related to the environment, but this is a very modest reading of what this lecture does. It is certainly not just a tour of the case law that you are offering us tonight, but rather a compelling analysis of the critical juncture at which the court finds itself, and asking the very important question of whether it can respond to the human rights, the rising human rights challenges that flow from climate change. And of course, there is no straightforward or easy answer to this question, but what your lecture eloquently brings to light is the lessons that we can learn from the existing practice of the court. Admittedly, the design of the convention system still raises a number of potentially significant obstacles before we can see a successful climate case before the European Court of Human Rights. And as you aptly point out, the convention has been designed with the rights of the direct victims of human rights violation in mind, and not the interest of potentially interest groups that would like to vindicate the law through actio popularis. And the question still arises as to whether this standing threshold can be met when it comes to the impact of climate change on individual human rights. And equally, you make us reflect on how far should judges step in and decide on the adequacy of policy decisions that are usually left to the democratic institutions of the state. And clearly, in that context, decisions relating to climate action or lack of climate action, as the case may be, are undoubtedly decisions that are for the democratic institutions to make. And of most relevance to the currently pending case of Duate before the court, you ask whether climate claims, which will naturally involve a transborder dimension, whether these claims can be squared with the jurisdictional limits placed by the European Convention on Human Rights system. So the question really here is there a potential for these limits to be relaxed? So there are indeed clear challenges that might still stand in the way of climate cases, climate claims before the court, but at the same time, you also remind us of the considerable distance that the court has already traveled since its inception, and also of the well-oiled tools that already exist and that the court could potentially be willing to adapt and use in this new line of litigation. So indeed, Judge Eicke, you have reminded us, you have limpidly reminded us of what the court has already managed to achieve towards environmental protection, even though there is no right to a healthy environment in the convention text. And that has not prevented the court from affording a level of environmental protection through indirectly via the protection of other human rights. And this has been made possible in particular through the living instrument doctrine that the court has usefully used to keep a pace of current development and keep a pace and of new human rights challenges. So that we see there that the court might be willing to adapt again and to use that tool to rise to the challenges brought by climate change. So once again, Judge Eicke, thank you for enlightening us so compellingly on the road that has been traveled so far and on the road ahead. And I would like to take this opportunity to ask for your thoughts, maybe for if you'd be willing to share some thoughts on two specific points that you have raised during the lecture and I found particularly intriguing. So you mentioned that the Paris Agreement does not acknowledge the link in its substantive part between human rights and climate change, and that apparently this is a deliberate omission. So I wondered whether you were willing to share some thoughts maybe as to what you think may have been the motivations for such an omission, especially considering that there has been a sharp rise in climate litigation since the adoption of the Paris Agreement, and also that often those claims are based or refer to the Paris Agreement. So I was also wondering whether you thought maybe that this omission was significant or not. And my second question, if I may, has to do with the issue of jurisdiction. And here I'm thinking particularly of the American Court of Human Rights 2017 advisory opinion on human rights and the environment. And in this advisory opinion, the court has quite groundbreakingly stated that when transborder harm that affects rights protected by the American Convention occurs, the individuals whose rights have been affected are considered to be under the jurisdiction of the states whose activities have caused the harm. And so really here I was wondering, especially considering that the court has also been willing to borrow from other systems and from other conventions, I was wondering whether the European Court of Human Rights might be inclined to borrow from its American counterpart here and to follow its lead and maybe transcend the traditional jurisdictional limits that exist in the current case law. Thank you very much.
Thank you, Virginie. Judge Eicke?
Thank you, Dr. Barral. Well, two difficult questions. Motivation is quite difficult to work out why the decision was taken, or why pressure appears to have been applied not to include it. And it's quite difficult for me to second guess, but it's the interlinking, of course, does play a role, or might play a role in the litigation, and views may have been taken about the merits or demerits of that. As I understand it, an earlier draft of the Paris Agreement included a draft Article 2, which would have included an express obligation to implement the Framework Convention on the basis of respect for human rights. Now, that, of course, is a very different beast to the phrasing that is now in the preamble, which effectively only requires respect for human rights in the measures taken to address the obligations under the Paris Agreement. But I must say I haven't studied it in great detail either, so I'm not sure how much further I can take that to speculate as to what might have motivated states to take the view that it was inappropriate. The other thing, of course, and this is, one has to look at the fact that this is, the Paris Agreement is a worldwide agreement. It's a UN-based agreement, and therefore it has a lot more member states and signatories than the Council of Europe, and therefore pressure may also have come from elsewhere, where even the basic fundamental rights which we take for granted within the European Convention of Human Rights are not as such secured and are disputed. So I don't think I can say much more about that. In terms of the Inter-American Court, we are of course very conscious of the work the Inter-American Court does, and we do look at their jurisprudence quite carefully, and there are regular interactions with the two other regional human rights courts to share experiences and the like. But I wouldn't want to predict whether we're likely to follow them or not. I think one has to be clear that there are, as much as there are similarities, there are also significant differences between the Inter-American system and the European system, and the instruments that the Inter-American Court can take into account. And there is, of course, a protocol in the Inter-American system which provides for environmental protection, something we don't have because the Committee of Ministers repeatedly has rejected the suggestion that may be a step worth taking. And again, as a court of law, it seems, especially when one applies the living instrument doctrine, one has to be conscious not only of where developments have been progressive, but also where the states who are the founding fathers of the convention, the member states, have deliberately taken a decision not to go. So, and that will also play a consideration in the approach one takes, and in the way I think one reads the Inter-American, the case law of the Inter-American Court. But as I said, it's one we're very conscious of, and which no doubt will when we get there, we'll get a fair bit of attention, both in Council's argument, no doubt, and in the court's consideration.
Thank you very much. Thank you.
Thank you very much, Judge Eicke, and thank you, Virginie, for your analysis and questions that followed up on that. I would also like to encourage our participants to put their questions to the Q&A, and we'll be delighted to draw on them and bring them to the attention of Judge Eicke. In the meantime, I've got one question myself, if I may, Judge Eicke. You have stressed, you have particularly underlined the importance of the living instrument doctrine in this area, particularly as a vehicle for enabling the court to play a more active role in providing protection when climate change intersects with human rights. Now, commentators quite familiar with critiques of the ECHR's application in certain countries, and that is also the case in the UK, will know, of course, that the living instrument doctrine is quite often attacked as a vehicle for judicial, and in this case, Strasbourg, overreach. So I'm wondering whether you would be concerned that the more active role for the court, which might mainly rely upon the living instrument doctrine, might give rise to such critiques. And I have to say quickly that on the other hand, you have been able to point out how the court prioritizes the margin of appreciation and subsidiarity. And so do you consider these two mechanisms to provide an effective defense against potential populist attacks upon the court that stress judicial activism and judicial overreach as a threat to national sovereignty?
Well, I think you've rightly identified the dilemma, which I was trying to allude to towards the end of my lecture. That I think the court has used the living instrument doctrine carefully and effectively, and as far as it has progressed down the route towards addressing environmental issues that came before it, and the interplay between environmental concerns and human rights. But it is also conscious that the living instrument doctrine seeks to build on developing consensus, both in relation to the substantive law and to some extent the role the court can play in giving effect to that. Because I think one thing one has to be always conscious of is that, of course, there are the court is only one means of giving effect to human rights, and is only one means of ensuring it. Now, one appreciates that it has a particular status in doing that, but it is only one means, and therefore, even though there may be violations of human rights, it may be that the court is not the right forum to give effect to them. But I think it is right that the court is conscious, and nobody will be surprised by that there is that tension you've identified, namely, we are a court of law and therefore required to apply the convention and our case law as we find it, and that those developments have to be done with a certain degree of care, because if they're not, as I said, there's a real risk to the system and to the effectiveness of the mechanism.
May, thank you very much for this answer. May I quickly follow up on this by noting in relation to the living instrument, I think you have also highlighted the importance of the court's ability to identify converging lines, to identify an emerging consensus in particular. And I'm wondering how that applies to the different groupings of nations, of contracting parties. One might put the issue like this. The European Union member states on the one hand, and those that lie outside the Union but within the Council of Europe on the other. And of course, when it comes to the member states of the European Union, there's a range of mechanisms that can enhance, that can facilitate, that can accelerate the type of convergence that you've been alluding to. So I'm wondering, is that divergence, is that variation between the EU member states and other members of the Council of Europe apparent to you, potentially including in relation to climate justice? And if that is the case, does the fact that the UK now have left the European Union going to have any effect in this debate?
We are conscious that there are different lines of development, different speeds of development, and I mean, you've highlighted the European Union as a kind of block of now 27 states who on some of these issues work together and therefore set standards. But I think we are very conscious as a court that we are a court for the 47. The EU has its own court, and that court, of course, has also handed down some very important judgments, also in relation to environmental protection, applying its very detailed secondary legislation and treaty provisions, which may enable the EU to move at different speeds to others. But the court is very conscious that we're a court of the 47, and therefore we look across the board at emerging consensus and at a coming together in which, of course, we have due regard to the standards that develop within the EU and take them into account. But what I think you're not going to see, and therefore I don't think there will be in that sense an impact on the UK, what you're unlikely to see is a kind of two-speed European Convention on Human Rights. We're very conscious that the rights and the convention has to apply, and the same standards have to apply across all 47 member states. And there can be no fast track and no slow track in that sense. Yes, we have that well in mind, and those standards in all kinds of areas are frequently raised before us by those pleading before us, and we take into account and study with great care. But ultimately, we look at the convention as a whole and all 47 member states. But again, sorry, this is a rather long-winded answer. That's not to say that all 47 have to agree before the living instrument doctrine takes things further. I mean, in a completely different context, in the Christine Goodwin case, when it moved to the recognition of transgender rights, there were still states, the UK being one of them at the time, who hadn't made that necessary step, and the court felt able to do so. But that's also that's an encouraging case, but it's also one that shows that the journey is sometimes a long one, because in that case, in which I appeared for the applicants in those days, was one in a long series of cases that had gone to the Court of Human Rights. And in all previous cases, they've been knocked back because the search for consensus in an issue that involved or was seen to involve very difficult social and societal interests took the court a long time to feel that that the consensus had reached a stage to adapt the convention or to interpret the convention in a way to give effect to that.
Thank you very much for such a comprehensive answer. There is a number of questions already in the Q&A, so let us draw on as many of them as we can. And well, of course, we're conscious of time, and we're conscious of the fact that in Central European time, it's not far from 8 o'clock already. So we promise to not keep you for too long. So one of our participants is asking about the potential impact of the kind of jurisprudence that you have referred to the European Union's upcoming Sustainable Corporate Governance Directive, which our participant explains will include mandatory human rights and environmental due diligence for companies.
I would anticipate that the convention as such will play a not unimportant part in that process, because of course the EU Charter ultimately draws inspiration from, and insofar as the provisions are, the rights protected are identical, has to be interpreted in line with the convention. So insofar as the kind of case law of the court highlights opportunities and already establishes obligations, I would expect that to feed into that process. The Charter also, of course, is very clear that the EU can go further than the convention, and one would expect, possibly in the EU context, that the EU might go further than the convention requires, particularly in the context in which this question is posed, which is, of course, potentially imposing human rights obligations on private actors. And again, I highlighted in my lecture the limits of the convention as being an old-fashioned, I'm sorry to call it that, but an old-fashioned first-generation human rights instrument, which is focused on the obligations of states to protect the rights agreed to those within its jurisdiction, that the step of using the convention to impose rights on private actors qua human rights is something which is unlikely to be drawn from us, but it's likely to be, insofar as it takes place, is likely to be something which where the EU will just go further on its own speed than we are, or at least have so far found ourselves able to.
And of course, there is always the interesting question about the judicial dialogue between the two courts, and the one taking into account the jurisprudence of the other.
Yes.
Katie Wooten, another participant, is making a reference to the African Charter and referring more specifically to group rights, and whether you might anticipate the development of a concept of group rights providing assistance with regards to greater protection in relation to environmental rights. I mean, I personally found particularly intriguing your reference to the standing requirements, limiting the capacity of NGOs to play the more active role that I suspect they would be willing to play in this area.
Well, yes, I think, again, as I said, in relation to Dr. Barral's question about the inter-American system, I'm of course we are conscious of the African system, but again, their development of people's rights, of course, and of group rights is, of course, something that is inherent in their system, and it's of the African traditions which have flown into the drafting of the instrument itself. The difficulty I think we have found to date, and as I said, I can't predict what we're going to do, how far the court is willing to go in the future, is the strict wording of Article 34, and the fact that the victim has to be effectively individually affected by an applicant has to be a victim, and as such has to be individually impacted. And therefore, the step to group rights, I think, is not a straightforward one for the court, and certainly not one where an easy transposition from the African system is necessarily lends itself.
Thank you. My colleague from Liverpool Law, Professor Konstantin Gechtziarou, is taking issue with Georgia and Russia number 2. And so he is contrasting the judgment of the European Court of Human Rights in that respect vis-a-vis what you were reflecting upon today. So he's pointing attention to the fact that the court, he's arguing, has removed protection from those who are within the active period of hostilities on the one hand, but on the other here, it is considering extending the convention to climate change.
Well, I mean, when you say we are considering, I mean, we're confronted with the cases that come to us, and therefore we've now got two potential and two more potential climate change cases coming to us. So we will have to grapple with that issue. I'm conscious that Georgia, Russia number 2 on that issue has been heavily criticized. I'm not sure whether the court would necessarily accept that it has been withdrawing protection from those within active hostilities, because that assumes that there would have been jurisdiction before, which of course was one of the points of argument. But I think that judgment also makes clear, and as I said, very conscious of the criticism that's been leveled at it, of the difficulties the court has in engaging with its very strict kind of territorial national sovereignty based conceptions, and the fact that it has extended that by its jurisprudence on extraterritorial effect in small steps, not always unidirectional, so to speak. But I think that case highlights the difficulty the court has with grappling with these issues, and I would anticipate not what the result will be, but that the debate and the issues about how one deals with the confines the court finds itself in within the text of the convention can accommodate what is especially is a global problem, and a problem in which all member states are affected, but all member states are responsible too.
Thank you. Bryce Dixon is inquiring about whether you feel that there might be scope for the court to develop Article 5. It's Article 5 jurisprudence, the right to security in that respect. And I will read this question in parallel with a question that Dr. Ruvi Ziegler is asking that relates to Article 3. So Ruvi is asking whether you envisage the court adopting an interpretation of Article 3 that would enjoin signatories from returning persons to areas susceptible to rising sea levels in the future.
Well, I mean, it's to some extent going into different directions. Article 5, I'm not quite sure. I can see at the moment how Article 5 would operate in this context, in the environmental and climate change context. So I must say I haven't thought of Article 5 being a mainstay of we might have to engage with, and I would need some time to reflect on that, and possibly a slightly more detailed conversation with Bryce over this. Article 3, as I said, I mean, we now see we have the decision of the UN Human Rights Committee. We have the French courts, actually the Court of Appeal, certainly without reference to the ECHR at all, confirming or quashing a decision to remove somebody to a country where the effects of climate change would significantly affect his health. And one may take the view that that is an extension, effectively, is an extension of our existing case law in relation to the deportation and removal of those who are subject to, who are suffering from serious mental conditions, and where their deportation or removal might have a serious impact, a serious life-shortening impact on their health. Of course, also an issue which is currently, again, before the Grand Chamber in a case called Savran against Denmark, where that is being considered. Whether, if confronted with the right kind of case, we would reach the same decision as the Human Rights Committee and or the French courts, I wouldn't want to say, but one can see the roots of such an argument, and the root of, the basis for such an argument in our existing jurisprudence. So it's certainly not something I would exclude.
Thank you. Jodian Corey is asking for your thoughts on the responsibilities of individual states to grapple with the migration consequences of climate change and climate refugees in particular as a new human rights issue. It follows up quite nicely from Ruvi's question.
Yes, but I'm not sure that my answer is going to go much further than the answer I've given. Again, because of the nature of the convention, we are most likely to be, and I think one has to again remind oneself that the court, as a court of law, deals with the cases that come to it under the circumstances that come to it, and therefore the most likely scenario of those kind of cases to come to us is where those fleeing climate change consequences are being refused entry or in a member state, or are being removed from a member state to their country of origin because they do not satisfy, according to the authorities of the state, the requirements either of refugee status or of humanitarian protection, or of any other form of protection that may be derived, for example, from Article 3 of the Convention. I can see that those cases may come to us, and we will have to engage with them. But again, that is likely to be, one anticipates, on an individual by individual basis rather than on a group basis. there are very few rights where very few bases within the convention where the court is almost by necessity required to look at the approach taken to a group, that's I don't at the moment see that happening. I mean, the one I think scenario, not where that arises, but one issue where we have had to look at groups and migration, again, of course, subject to quite some criticism in the outside world, is the ND and NT case on collective expulsion in the Melilla exclave of Spain, where one had to look at the duty to consider the circumstances of the individual case. But that's rare, and how that would arise in a migration case arising out of climate change, I'm not currently sure I can conceptualize that.
A couple of our participants are commonly referring to the Paris Agreement. They're taking this as a point of reference in relation to your discussion of the court's search for consensus. So how important a point of reference that is? I mean, one of the participants in particular is saying that this is a very concrete illustration of emerging, I would say, emerging universal consensus in this area.
Yes, and as I say, I mean, as I tried to highlight, it's interesting that our case law hasn't historically looked much to other instruments, or certainly not referred to other instruments when looking at the substantive rights. But I think the difficulty that may arise is that the Paris Agreement sets down a standard of what is to be achieved. But the difficulty, and to some extent the reason why this litigation is accelerating and there's now so much of it, is that there's very little consensus as to how that is to be achieved. And I think when an individual comes to us to seek a remedy for a breach of their rights, it is not only for us to look at what's the standard you have to achieve, but also what is the court is the state doing or not doing what it can in order to achieve that. And that is one where I think the court will, and that's when in the past, certainly, the court has given a very wide margin of appreciation. And in the Athanasoglu case, has made it quite clear that those are really decisions for the domestic authorities. So I think yes, the Paris Agreement will play a role and will matter, I anticipate. But one of the more difficult questions is, how do you achieve it? And as I understand it, one of the issues in the Urgenda case, which was successful domestically, was in part because they didn't take the measures necessary to achieve the standards which had been laid down in domestic law. And therefore, there was already a mechanism where the domestic law had recognized that. We still find ourselves in situations where those standards are laid down in the Paris Agreement, but the way to get there is highly controversial amongst those legislators and members of the executive of our respective member states and those beyond the Council of Europe.
I'm very conscious of time, so I will take just one or two more questions if you will allow me. One of our participants is simply drawing attention to the importance of the right to life, which you have so clearly illustrated in your presentation. And again, from the viewpoint of the question or the observation that I made earlier on in relation to certain aspects of the convention creating skepticism in specific contracting parties, the right to life and the duty to act in line with the right to life being one of them. Do you again anticipate that significant reliance on Article 2 in the context of climate justice cases might continue to create that friction with that type of contracting party that is concerned about the extension of the applicability of the European Convention on Human Rights in these areas?
I can see the argument. I mean, articles frequently and will be relied on, no doubt, in these cases, and not surprisingly, in light of the very dire and very stark but justified warning of Sir David Attenborough. But that there is an issue as to how far, as I said, the court has, in relation to environmental accidents and the like, and has already applied Article 2, and to some extent Article 2 has probably been the more productive article under to some extent in this area. How far one can push that is I think a question which again will be subject to debate, because if one looks at insofar as there is, if one looks at the convention rights, you know, Articles 2 and 3 were always and are generally treated as being kind of, you know, they are absolute and they're not subject to qualifications. They are not subject to, with very minor exceptions in relation to Article 2, the right to reservation, and therefore there is a certain danger in pushing those absolute rights beyond their limits in terms of finding the acceptance. I think the court has done that and has done so quite prudently to date. And as I said, I have no doubt that large parts of the argument will focus on that issue, and the court will have to grapple with it. How far the court will go, as I said, is difficult to anticipate.
Judge Eicke, I cannot thank you enough. We are deeply grateful to you personally, to the European Court of Human Rights, and our colleagues at the Council of Europe for the honor that you have bestowed upon us to deliver this inaugural annual human rights lecture. We're very thankful to you and are very much looking forward to staying in contact with the Council of Europe. The timing could not be more pertinent. There couldn't be more urgent for us in the UK to continue the debate, to remain closely linked with the court and the Council of Europe more broadly.
Well, thank you very much, Professor Giannoulopoulos, for inviting me and for giving me this opportunity to speak to you and to your students and everybody else who listened and participated, and for doing me the honor of being the inaugural lecturer at your annual human rights lectures, which I wish the greatest of success. And I hope one day we will have the opportunity of having one of these encounters in person when I'm able, again, with more currently possible, to travel to London, which is of course my home, and to see you. So thank you very much to you and all your colleagues, and again my gratitude to the warden and to all participants. Thank you very much.
It would be a real privilege. We're very much looking forward to this. A special thanks to your colleague Andrew Cutting for all his support with this event, other colleagues at the Council of Europe, and to you, Virginie, thank you very much for your analysis and questions. Thank you all so much, and see you soon. Bye.
Thank you very much. Bye-bye.